Yeah, be the last.
Good morning. Welcome to the Kansas Supreme Court, those in the courtroom and those online. I would like to call case number 127055 in the matter of June R. Crow Johnson.
Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. I'm present and ready for argument.
And I would just announce that I do not see Ms. Crow Johnson in the courtroom today. So Mr. Vogelsberg, if you would like to begin your argument, you may.
I would just like to start off my comments today about noting the efforts that the ODA had made to contact Ms. Crow Johnson about today's oral argument. Oral argument in this case was originally scheduled for May 9th, but due to Justice Six's passing and his funeral scheduled for that day, it was rescheduled for today's date. And so once the court issued its order scheduling it for today, we had sent notice by regular mail to respondent's last registered residential address here in Topeka, which was a P.O. box number, as well as 3 addresses that during our investigation of the disciplinary complaints we had found were associated with her either living. There's 2 residential addresses and a P.O. box address up in Lincoln, Nebraska, that we also mailed notice to by regular mail. In addition, we also sent notice to respondent's last registered email address as well. Just note that the ODA received notification that the P.O. box here in Topeka was closed and that no forwarding address was on file. I checked yesterday and that the letters mailed to the addresses in Lincoln had not been returned as of yet to the ODA. And then finally, the notice that was emailed to respondent's last registered email address, we received notification through Outlook that the email had been delivered to the respondent's email address, but I don't know whether or not she'd actually opened it and read the email. All I know is that it had been received or been sent successfully to her email address. We never received any bounce back notification. So those were the efforts that we took to notify the respondent of today's oral argument. As far as the status of Ms. Johnson's law license during the 2022-2023 registration period, she changed her registration status from active to inactive. And then for the next registration period, 2023 to 2024, the current registration period, she had failed to pay her inactive fee license at $65. And so on October 10th of 2023, her license was administratively suspended and has remained administratively suspended since that time. Regarding the disciplinary matters, on August 22nd, 2023, the ODA filed its formal complaint against the respondent, alleging that she committed numerous rule violations in connection to 2 separate disciplinary complaints that were filed against her. Pursuant to Supreme Court Rule 215A, the ODA served the formal complaint and notice of hearing upon Ms. Johnson at her last registered business address here in Topeka. In addition, we sent the formal complaint and notice of hearing also to the addresses in Lincoln, Nebraska, and then also as well served the pleadings on her to her last registered email address. Despite that, Ms. Johnson failed to file an answer to the formal complaint, and she failed to appear for her disciplinary hearing on October 24th of 2023. The evidence presented at the hearing established that in regards to the first complaint, DA 13872, Ms. Crow Johnson was appointed in June of 2019 to be the trustee of a trust established by her client, JC. The trust named RC, JC's brother, as one of several beneficiaries of the trust and named RC as a trust advisor who was entitled to receive annual accountings of the trust's assets. Furthermore, the trust required respondent to consult with RC regarding the sale or purchase of any trust assets. JC passed away in November of 2020. Shortly after, respondent contacted RC to inform him that she had JC's ashes in her possession. During respondent's phone call with RC, she did not disclose the existence of the trust to RC, let alone notifying him of his duties under the trust as a trust advisor. Based on the terms of the trust, upon JC's passing, Ms. Crow Johnson was to pay taxes for the trust and distribute assets to the trust to several charitable organizations and family members of JC. She failed to do so. Subsequently, RC attempted on numerous occasions to contact her respondent regarding his brother's estate. The respondent would never respond to RC's request. Ultimately, RC retained an attorney who was able to discover the existence of the trust and RC's appointment as a trust advisor. RC filed a lawsuit against respondent in Shawnee County District Court in March of 2022 to obtain an inventory of the trust assets, as well as an accounting of the trust receipts and disbursements during the respondent's term as trustee. Despite respondent being served with the lawsuit, she failed to file an answer or appear for a hearing on June 9th of 2022. The district court granted RC's partial default judgment and ordered respondent to provide a complete inventory and accounting of the property contained within the trust within 14 days. She failed to comply with the court's order, resulting in RC following an accusation of contempt on July 7th of 2022. A hearing on the contempt motion was held on August 2nd, 2022, where respondent appeared for the hearing. Under questioning from the judge, respondent claimed that she had prepared and submitted tax returns for the trust for 2020 and 2021. She admitted she had not distributed assets of the trust. She also said that she had a box of documents related to the trust that she was trying to locate within her home. At the hearing, the court ordered respondent to provide the box of documents within 2 weeks. Respondent failed to produce the documents that were requested. A second hearing took place on September 8th of 2022, where respondent admitted to failing to produce the records she was ordered to provide to RC, stating that she had been unable to locate the records in her home. Respondent again indicated to the court at that hearing on September 8th that she had prepared and filed tax returns for 2020 and 2021 for the trust.
Can I ask you a question about that particular fact, her testimony before the district court? I think it's paragraph 31 of the final hearing report. Indicates that her testimony cited says that she prepared the returns. I don't know that I saw any specific testimony from her that those returns that she had allegedly prepared were actually filed. Is that her testimony anywhere in the record?
You said paragraph 30?
31, I believe, in the final hearing report.
Either at the August 2nd or the September 8th hearing, the judge was questioning the respondent about whether the tax returns had been filed. And she specifically said, I didn't file them electronically. I submitted them by mail.
Okay, in one of those two hearings.
But she certainly was indicating to the judge and to RC that they had been filed.
Beyond mere preparation.
Yes. Yeah. So at the September 2nd September 8th hearing, court ordered respondent to provide the box of documents within 2 weeks, and she failed to produce that. Again, and as I mentioned in the September 8th hearing, she again indicated to the court that the tax returns had been prepared, filed in 2020, 2021. Ultimately, the court found the respondent in contempt of court and sanctioned her by ordering her to pay RC's attorney's fees, which totaled $9,981.54. And ultimately pay that money. Respondent ultimately failed to produce the records. Contrary to her claim, RC ultimately discovered that the tax returns for 2020 and 2021 had not been filed for the trust. Ultimately, RC filed a complaint with the ODA in August of 2022. Respondent failed to provide a written response to the complaint or to cooperate in a subsequent investigation. The second complaint, DA 13872, respondent agreed to prepare and file the 2020 federal tax returns for the Topeka Bar Association. Respondent later assured the TBA that she had filed the returns by mail. In October of 2021, the TBA received notice from the IRS that its 2020 tax return had not been filed. When the TBA executive director asked respondent about the notice, respondent assured her that she had submitted the 2020 tax return and that she would look into the matter. Respondent eventually stopped communicating or responding to communications from the TBA regarding their inquiries regarding the status of the tax return, and failed to respond to requests from the TBA asking that she return documents that the TBA had provided to her for the purpose of completing the 2020 tax returns. Ultimately, the TBA learned that the 2020 tax return had never been filed with the IRS, which caused a delay in getting the 2021 and 2022 tax returns filed. Ultimately, the TBA had to retain another person to complete tax filings. Fortunately, the TBA was successful in having the IRS waive thousands of dollars in penalties that were assessed against it as a result of the respondent's failure to file the tax return on time. The TBA filed a complaint with the ODA regarding response conduct in March of 2023. The respondent failed to provide a written response to the complaint and she failed to cooperate in the subsequent investigation. Hearing panel filed its report November 29th of 2023, concluding that Ms. Crow Johnson's conduct violated 1.3 diligence, 1.4 communications, 1.15 safekeeping property, 1.16 withdrawing from or terminating representation, 3.3 candor toward the tribunal, 3.4C knowingly disobeying an obligation under the rules of the tribunal, 8.1B knowingly failing to respond to a lawful demand for information from a disciplinary authority, Rule 210B failing to provide a timely response for information during an investigation, 8.4D conduct prejudicial to the administration of justice, and Supreme Court Rule 2060, the attorney registration rule, which requires an attorney to amend or change their registration information within 30 days of a change of the contact information. Ultimately, both the ODA and the hearing panel recommended that Ms. Crow Johnson be disbarred based on Ms. Crow Johnson's underlying conduct in these two complaints, her failure to cooperate in the investigation of either complaint, her failure to appear for her disciplinary hearing, and her failure to appear for today's oral argument. I would ask the court to adopt the recommendation of both the ODA and the hearing panel and disbar the respondent. Unless the members of the court have any questions for me, I would waive the remainder.
I see no questions.
Thank you.
Thank you. I would request that the clerk of the Kansas court please file an affidavit with the court indicating any of the efforts that about service or attempt of service that may be reflected in the court file. Thank you. With that, court will be adjourned.